Thank you for joining us. My name's Rob Morris. I'm with the Trust and Estates Department here at Stark & Stark, and
I'm Paul Norris. I'm also with the Trust and Estates Department. The concentration is litigation aspects of trust and estate.
We're here to present to you on New Jersey estate litigation. The reason for this is oftentimes we have a lot of clients that come to our office. They're concerned about what's happened with particularly mom and dad's estate, or it may be a friend or a relative. Another person's become involved in their lives and it's encouraged mom and dad either make gifts during their lifetime, alter their will, or change a beneficiary designation. Oftentimes, because it is so personal, they're confused, upset, and not sure what to do. So the purpose of today is to give you some basic information on how this process works in the state of New Jersey. The classic type of lost inheritance is a modification to particularly a will, but also a trust. This can affect you in one of two ways. It can result in either a complete disinheritance, or it can result in a reduced share of your estate under the will or the trust. This is often accomplished through changes in a will that are done shortly before the individual dies. And there are a number of warning signs which may indicate that some improprieties were involved in the change. The first one is whether a new lawyer is invited into the drafting process. A lot of times individuals have lawyers that they repeatedly go to for various legal matters throughout their lives. What you'll see with a lot of these modifications is suddenly at the 11th hour, a new lawyer switched in and the will's modified substantially. This can be a major issue, particularly if the person that benefits from the change knows the new lawyer or has had a prior attorney-client relationship with the new lawyer drafting the will. In some instances, due to the availability of online wills and other legal sources, you may actually see the beneficiary involved in drafting the new will. And a related issue is if the beneficiary is involved in changes to a beneficiary designation, which we'll cover in a few minutes. Obviously, another warning sign is the timing of the changes. What you'll see many times is that the changes are made within the last year of the individual's life, or in some circumstances may even be made within months or weeks of the individual passing away. There's some other warning signs to look for that may be less obvious. Amongst others is whether the individual that benefits from the change is a witness to the will. Other types of lost inheritance, so we're putting the will aside for a minute. What are some other things you need to look at? What other types of lost inheritance can involve retirement accounts? That's usually a big asset that a lot of people have, and it may be the second largest behind their house. Those involve IRAs, 401ks, and 403bs. And what you need to look for there is whether the beneficiary designation was changed, again, particularly shortly before the individual passes away. Sometimes investment and bank accounts allow you to do one of two things. One, either designate a beneficiary or create a joint account. Again, if these relationships were created shortly before death or after the other person became involved in the decedent's life, there may be an issue to look out for. A major one that's less obvious, but we're starting to see more and more, are gifts made by a decedent before they pass away. And this can be done in one of two ways. The first one is where the beneficiary of the gift applies pressure on the person while they're still alive. The person responds to the pressure by giving the individual what they want. They'll usually issue a check or some type of outright transfer. In some circumstances, the person benefiting from the gift may use a power of attorney and may go ahead and write the check to himself or herself directly. You also need to look into real estate transfers. How is the decedent's real estate titled, both at death and before? Again, you're looking for changes that were made that benefit particularly individuals that are trying to influence the decedent.
When you're considering challenging a will or a trust, there are certain things that I like to advise a client that we should do really at the inception. And the first thing would be consider filing a caveat. What a caveat is, it's a document that's filed with the county surrogate's office which prevents the will you're seeking to contest from being probated. What that does is stop the other side in their tracks. In other words, they can't probate the will, they can't be appointed executor or executrix, and it puts the will in a situation where nothing is going to happen until either you file a complaint to contest the will itself, or your adversary files an action to probate the specific will. So it's always good to file a caveat if you have their opportunity to stop the other side in their tracks before anything happens. Once the caveat is filed, as I said above, a will contest can be commenced by yourself to challenge the will, to invalidate it, and perhaps revert to a previous will, or the person who's the proponent of the will can file a contest to actually have that will probated, at which time you can assert your claims to invalidate the will. During a will contest, there are some special rights which may exist. A spouse might be entitled to an elective share. There might be a child that was born after the will was drafted, which may be entitled to a share of the estate. And there's other considerations that you could take account in. And to give you some examples, you have to consider, what if the person were to die intestate? That means without a will. What would be the distributions at that time? As among as a multitude of possibilities that if the will is invalidated or reverts to a previous will, you need to consider what the distributions could be. The period to challenge a will is actually quite short. Typically in New Jersey, you may have civil litigation can be commenced 4 years, 6 years after an action, whereas a will contest, if it's in New Jersey and you're a New Jersey state resident, you only have 4 months from the date the will is probated. If you're an out-of-state resident and the will is probated in New Jersey, it gives you 6 months to challenge the will. The court can, for good cause, extend that period for 30 days. However, it's always recommended the will contest be commenced within the short 4-month period of limitations, just to be safe. And also, you have to consider there's a 60-day notice period, which could potentially reduce that period as set forth above. Extensions. One of the reasons that you may get an extension to file a will contest is if you were not provided formal notice of probate. The probate statutes in the state of New Jersey require that heirs of the estate or potential heirs of the estate, such as a brother or sister, be provided notice. If there was a failure to provide notice, that could justify an extension. If the court were to find that the potential executor of the estate committed a fraud upon the court as far as representing that you were served but in fact you weren't, or other things, that may likewise grant an extension. When you want to challenge the beneficiary designations of the trust or even transfers of a trust, those periods of limitations are somewhat longer than what you would have to challenge for a last will and testament. I myself, as an attorney, if I'm going to challenge a will, a lot of times the trust instruments can be created by the will, or they can be funded by a distribution from the will. So the safest thing, in my opinion, is really to commence the challenge to the trust or beneficiary designations at that time. Of course, depending upon the nature of the trust and the distributions themselves, the time period of challenge may be somewhat longer. During a trust, you can also contest designations in court. You can contest the person who is being appointed as trustee. You can contest who is going to ultimately serve as the trustee and in what locale the trustee will be administered. There are practical issues to consider as well. Have the assets already been transferred? Is it going to be tough to recoup the assets? Have the assets been converted? Also, you want to consider what's the nature of what you're challenging. In other words, you want to have potentially a long, drawn-out legal battle if the ultimate assets you're seeking to contest are simply not worth it. So that's another practical issue to consider. And like a will contest, that is something you should consider as well. In order to challenge a will in transfers made thereunder, one of the main reasons to do it is people allege that there was undue influence exerted over the testator. And what that means is that a person provided information to the testator in an exercise and influence over the testator to the extent that the testator's true wishes are not actually reflected within the will. In other words, it's the wants and desires of another person rather than the true desires of the testator. And the courts have described that as an overmastering influence over the testator, which thereby caused a change in the will to benefit the person who's the proponent of the will. Another way to challenge a will is lack of capacity. Did the testator have the capacity to execute the will on the day that it was drafted? Did he understand the will that he was drafting? Did he understand the conveyances which were being made? Was he suffering from severe medical conditions which could have affected his ability to execute such a will? And also you have to look at the authority to make lifetime transfers and also whether or not there's fraud. In essence, the authority to make lifetime transfers, was the property able to be transferred via lifetime transfer, such as a life estate? Was that even possible? Also, the issue of fraud. Was there fraud in the execution of the will? Was there fraud in the drafting of the will? Fraud covers really a wide span of areas in which you can challenge a will. But I would say the two main areas that a will challenge are undue influence and lack of capacity. How does estate litigation work? Well, the first thing you want to do is you want to file a caveat, as I suggested. And the next thing you would do would be file a complaint. The filing of a complaint is a verified complaint that would be filed with the surrogate's court, and that would start the process. After the complaint is filed, there would be discovery, which would involve taking depositions of potential witnesses, taking depositions of doctors who may have information, taking depositions of anybody who may have knowledge as to the drafting and the execution of the will. That may also be in the form of written questions and document requests. As with any estate litigation, there's always a possibility of settlement, and oftentimes mediation is a good way to resolve estate litigation, simply due to the fact that a lot of times the assets you're fighting over are not really particular one parties, but instead the decedents. A lot of times the last possibility in estate litigation is a trial. And trials really take place in a very small minority of the cases because a trial is an absolute. In a trial, you either win or you lose. And you also, before a trial, you should consider, if I do win and it reverts to the previous will, what would those distributions be? Or if in fact it goes intestate, that means without a will, what's the potential distribution?
Thank you for listening here today. We have a few take-home points that we want to emphasize as part of our presentation. The first thing is, if you've been affected negatively by either a change in a beneficiary designation, a change in a will, or a change in a trust, you have rights. Individuals can't do that. The change was made improperly. You have an ability to challenge that in court and assert your rights. The second major take-home point is that the time windows in the probate field are very short. It's important that you assert your rights quickly because there are a number of reasons why your rights may be affected if you sit on them. Even if you have waited a short period of time, it's important that you do speak with an attorney. Sometimes, even though some of these time periods have passed, there may be ways of making other challenges or working around them. So it's important that you speak to an attorney about asserting your rights. And lastly, every case is fact sensitive, which makes consultation with legal counsel an essential component of asserting your rights. If you have any questions, feel free to call either Paul or I. Paul's number, if you'd like to reach him, is 609-895-7325, and my direct line is 609-945-7617. Thank you for listening.